21 CR 11553, State of Texas versus Leela.
All right, family. Welcome back to Shazi Gavel, because today we've got two completely different courtroom worlds colliding in one video. And trust me, this one has everything. Probation violations, deferred adjudication turning into real prison time, a defendant trying to explain away behavior as panic, and Judge Boyd doing what she does best, cutting through excuses like a hot knife through butter. First up, Leela McFarland already on deferred adjudication for assaulting a peace officer, and that is not a small charge. And now she's back because she didn't follow the rules of her residential supervision program and got discharged, which is basically probation's way of saying, we tried, she did not cooperate. And then we shift into a completely different case, Christopher Trinidad, an aggravated assault with a deadly weapon case. But here's the twist. Judge Boyd goes deep into parenting, sobriety, CPS involvement, then drops the most unexpected courtroom moment I've heard in a while, with Cheesecake Factory menus and chicken tenders making a guest appearance. So the question is, are these people learning from probation or just surviving it until the next mistake? Let's break it all down.
McFarland, now parties announced for the record for the state.
Jason Gearhead, Your Honor.
Defense.
Richard Garcia for the defense. Ready, Judge?
Are you Leela McFarland?
Yes, ma'am.
Showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
I did, Your Honor.
Are you the same Leah Beth McFarland who was placed on deferred adjudication in 2021 CR 11553 for the offense of assault peace officer judge on February 23rd, 2022 for a period of 5 years? Is that you?
Yes, Your Honor.
All right, state.
Violating condition number 41, on or about the 18th day of July 2023, in Bear County, Texas, the defendant Leah Beth McFarland did not there failed to comply with the rules, regulations, or instructions of the Bear County Community Supervision and Corrections Department's duly diagnosed residential facility, and that the defendant was unsuccessfully discharged in violation of condition number 41.
How do you plead to that? True or not true?
True.
Did you understand by pleading true to violation of condition number 41, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison?
This right here is what people underestimate about deferred adjudication, and it's a legal trap if you don't understand it. Deferred doesn't mean case disappeared. It means we're delaying your conviction, but you are on a tight leash. And if you break the terms, boom, the court can adjudicate guilt and sentence you within the full felony range. Judge Boyd is making sure the record is crystal clear. Leela is admitting a violation that can legally take her from probation life to prison life in one hearing. And notice the careful courtroom language. She's not threatening her. She's giving a mandatory warning. This protects the case from appeal later, because the defendant can't claim, I didn't know the consequences. And viewers, this is important. Condition 41 is about residential rules. And that's not oops, I was late once. That's a structured program where compliance is everything. If you're discharged as unsuccessful, probation sees it like you failed treatment, failed supervision, and failed accountability. Question for you, if you were the judge, would you see this as a mental health struggle or total refusal to follow rules?
And up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition 41?
Yes, Your Honor.
Court will find violation of condition number 41 true. Is there a proposed resolution?
Yes, there is, Your Honor. And that is to adjudicate guilt or revoke the individual's community supervision, sentence her to 2 years of the Texas Department of Corrections.
All right, probation. How was she doing other than not completing this? All right. So is there a reason you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right. State your name for the record.
Leah McFarland.
All right. So what happened?
I got on probation And I paid the fine, I did my proof of address, I showed up for visits. But what I didn't get done was the mental, or the CTA, it's some kind of, drug and alcohol maybe, and then there was a mental health exam, but I got those both in jail the last time I was incarcerated.
So why are you not following the rules with mental health?
Oh, I went to DDRF and I don't know, they said that I panicked a lot and they said that I was talking when I shouldn't have, and I just got a bunch of write-ups that
All right,
I'm not.
just one moment. Probation, any objection to the court reviewing the
No,
documentation for probation?
No, Your Honor.
No, that you're making it seem like these were light infractions. These were not light infractions on your part.
I'm sorry. I was trying.
No, I mean, when you call somebody an F and B, that's not a light infraction.
Oh, Judge Boyd just did the courtroom version of, let me stop you right there. Because this defendant is trying to frame it as, I panicked, I talked too much, I got write-ups. Like she got written up for chewing gum in class. But the judge isn't reading a talking out of turn report. She's reading behavior that screams aggression, disrespect, and instability in a structured program. And here's what's deadly in probation situations. The judge cares less about your excuses and more about your pattern. Also notice something subtle. Judge Boyd calls out the minimization. That's huge. Courts hate minimization because it signals no accountability. And accountability is literally the currency of probation. If you're on a case for assaulting a peace officer already, and now you're in a residential facility calling staff names, disrespecting rules, creating conflict, Judge Boyd is thinking, so you didn't learn the first time. And now the air in that courtroom changes. Because once the judge publicly says, these were not light infractions, that's the warning shot. That's the moment you can feel the sentence approaching like footsteps down a hallway.
All right. Anything, counsel? Any questions?
No, Your Honor, we're just asking that you follow the agreement with the state.
All right. The court is going to find violation of condition number 41 true. Court is going to grant the motion. Court is going to sentence you to 3 years in the prison, give you credit for any time served. I'm going to show you what's entitled trial court certification. You can go around, Richard. I'm going to show you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Do you understand? You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Do you understand?
Sort of. Can
All
you
right.
explain it more?
Sure.
Okay.
So you can file a notice of appeal or have your attorney file a notice of appeal. That notice of appeal is not for the fact that you are on deferred adjudication. Do you understand?
Yes.
But the notice of appeal can be based upon the allegations that were in the motion. Do you understand? I'll let your attorney explain it
I'll
to you.
explain it to him.
All right. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yeah.
All right. Good luck to you.
Thank you.
We can go off the record. You cannot use your mental illness to be mean to people. Do you understand?
Wheel. That line right there deserves to be clipped and replayed. Because Judge Boyd just said something that applies way beyond this courtroom. Mental illness explains behavior, but it does not excuse cruelty. And I love that she said this off the record. because it means she's speaking as a human being, not just as a judge checking legal boxes. It's basically Judge Boyd telling her, stop weaponizing your diagnosis to dodge accountability. A lot of people don't understand. Courts do consider mental health, but they also consider personal responsibility. And probation programs, they're built around one rule. You can struggle, but you must comply. You can ask for help, but you cannot attack people and call it therapy. This also signals why Leela lost the judge. Because if you had truly severe anxiety or mental health crises, the record should show treatment plan, medical referrals, compliance attempts. Instead, it's write-ups and disrespect. That reads like character, not condition. Question for you. Have you ever seen someone use mental health as a shield for bad behavior? Where do you draw the line between illness and accountability?
Yes,
All right, good luck. 23 CR 2912, State of Texas versus Christopher Trinidad. Can I have parties announced for the record for the state?
Travis Banks of the state of Texas.
Defense.
Rafael Leal for Christopher Trinidad.
Are you Christopher Trinidad?
Yes, Your Honor.
Counsel, have you received all the discovery and did you review that with your attorney?
Yes,
I'm sorry, with your client?
yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Trinidad, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Trinidad, I'm showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony.
All right, new case, new energy, and this is not light work. Aggravated assault with a deadly weapon is one of those charges that immediately changes how the court sees you, because the law treats it as you didn't just get into a fight, you escalated into potentially lethal danger. Second-degree felony means 2 to 20 years, up to $10,000 fine. So Judge Boyd is again doing what good judges do, making sure the defendant understands the stakes. But here's what's fascinating. Despite that heavy charge, the defendant is applying for deferred adjudication / community supervision, meaning the court is considering giving him a chance. That's major. And I want viewers to catch this. Deferred adjudication in a deadly weapon case is not automatic. That's a gift. That's the court saying, we believe you can be supervised without becoming a threat. But probation is also a contract. Mess up, and you're facing the original punishment range like a guillotine waiting to drop. So now I'm watching the defense very closely, because the way they frame this incident decides everything. Accident, family dispute, provoked, or pattern of violence? Let's see.
Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, the situation with my client was that he was a security guard. Got home, there was an argument. It ended up in him being arrested. Through my investigator, there was we approached the complainant. The complainant, it's fine with not wanting to pursue anything further against my client. And in fact, she signed out of her own volition and on accord a affidavit of non-prosecution. However, given my client's situation, and he accepted the agreement that was presented to you, and he's willing to abide by those conditions, Judge. And I also have a motion in order for the investigator that helped me out in assessing the case.
All right, so Mr. Trinidad,
Yes, ma'am.
what is this that I'm reading the police report about your video recording? What was that about?
The video recording?
Yes, in the police report, it says that you became enraged because one of the complainants told the other complainant to be careful because you were recording. They said that wasn't characteristic for you. So what
Oh.
is the recording about?
No, I'm just upset, Your Honor. I just,
Well, were you recording or not?
This is where Judge Boyd becomes a human lie detector. Because did you catch what just happened? The defendant answers like someone trying to talk his way around the truth instead of through it. The judge asks a direct question about recording, and he responds with emotion. I'm upset. That's not an answer. That's a dodge. Then we get the classic courtroom confusion. Yes, recording. Oh, no recording. No recording others. Like, sir, the judge is not asking if you were filming a documentary for Netflix. She's asking whether you were creating evidence, intimidating someone, provoking, escalating, or violating privacy. And the police report matters because Judge Boyd treats it as a warning sign. The report claims he got enraged when someone told another person, "Be careful." He's recording. That implies the recording itself had some control dynamic attached to it. And then comes the nuclear word, "They're my family." Oh, because family situations create the most emotionally explosive court cases. They have history, they have grudges, and they usually have repeat contact. Which is why Judge Boyd is already thinking, if this is probation, he's going to need no contact orders. Be honest, do you believe him here? Or does this feel like he's rewriting the story in real time?
Was that recording?
Yes, recording,
Oh, no, ma'am.
recording other individuals because that's what's in the police report.
No, ma'am. Sorry.
How do you know these people?
They're my family.
Ah, so we have another family situation. So where are you going to be living? By yourself at another location because you're not going to be allowed to have contact.
I have another location where I can look to. Yes, Your Honor.
All right. Do you have any prior mental health diagnosis?
No, ma'am.
Are you employed?
I was at that time,
Doing what?
security officer.
All right. Do you have any children?
Yes.
What are their ages?
My son is 13. My daughter is 22, but she lives with my previous wife.
And so where's the 13-year-old?
13 is at home
With, who's he with?
with my wife.
Okay. So you and your wife are still together?
Yes, ma'am.
And who is your wife? What's her name?
Maria Chavez.
Ah. So what's the name of the 13-year-old, the first name?
Felix.
State, you put in here no contact with Chavez. Who is Chavez?
Sorry,
I believe it is a complainant, Judge, and if we can make it not in injurious contact with Ms. Chavez, I don't think.
All right, I won't do that unless you can file a motion. She can appear by Zoom if she wants to appear by Zoom, but I don't do no harmful or injurious unless I've spoken to the complainant.
Your Honor, that is the complainant, Maria Chavez. I neglected to put the first name.
All right, no problem. So the court is going to sentence you to 4 years deferred adjudication, $400 fine probated, taking consideration county court cause number 704628. There's an affirmative finding of family violence.
Okay, pause. Because this is where a lot of viewers get confused. Judge Boyd says 4 years, but that doesn't mean 4 years in prison. That means 4 years on deferred adjudication / probation supervision. And then she drops the key legal grenade, affirmative finding of family violence. That matters big time. Because even if he avoids prison, that finding carries long-term consequences. Firearms restrictions, future case enhancements, family court impacts, employment issues, especially security-related jobs. Then you've got BIPP, the Batterers Intervention and Prevention Program. That tells you the court believes this wasn't just a misunderstanding. The court sees it as behavior needing structured correction. 200 hours of community service is heavy. That's Judge Boyd making sure he's investing real time into paying back society. It's not just signing papers and going home. And the no contact list? That's serious too. Because in family violence cases, victims often go back, forgive, and the cycle repeats. Judges know that. So they impose conditions to interrupt the loop, especially when the defendant says, "They're my family," meaning he'll be around them unless forbidden. This is Judge Boyd balancing compassion with caution. She's giving him a chance, but she's also putting him in a legal straitjacket.
BIPP course, 200 hours of community service restitution. There's to be no contact with Felix, Elaine, and Maria Felix Chavez. Counsel, once you set up a hearing and they appear by Zoom, the court will reconsider.
All right.
I'm going to want parenting classes and probation, whatever parenting classes you feel are appropriate. Once you complete those parenting classes, then the community service hours will be deemed satisfied.
Yes, yeah.
There's to be regular reporting by Zoom or in person. Are there any drug issues with you? We're going to do random UAs, field visits, one time per month for 4 months. If there's no issue with the field visits, then probation, you may discontinue those. Probation, is there anything else he needs? All right. The last name of everybody I'm going to give you is Chavez. All right. Is there anything else? Is there anything else you need from the court to be successful in this probation?
No, ma'am.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
Proving employment.
Ah, thank you. I knew I was forgetting something. So there's going to be, we're still on the record. Added to your condition is proof of employment within 15 days. There's to be no employment as a home health care provider or with minors. Do you understand?
Yes, Your Honor.
And what I can tell you, because this is an affirmative finding of family violence, you're not allowed to have any weapons. So you're going to have to seek new employment.
Now, this is a courtroom detail most people miss, and it's incredibly telling. Judge Boyd is restricting employment involving minors and home health care. That means the court is thinking about vulnerability and supervision, jobs where you're alone with people who can't easily defend themselves or report misconduct. And notice how Judge Boyd connects the dots. Family violence finding to no weapons, to which impacts employment. That's not random. That's the court being realistic. A defendant might say, "I'll just go back to security work." And the judge is essentially saying, "Not with this case and not with these findings." This also signals what probation really is. It's not just don't commit crimes. It's court-managed lifestyle correction. They tell you how to live, where to work, who to see, what to take, what not to take. And it's strict because it's meant to prevent relapse into criminal behavior. And honestly, the fact that the judge is giving him a path, proof of employment, parenting classes, structured conditions, shows she wants success. But she's also saying success means responsibility. No loopholes, no sketchy work, no risky environments.
All right. And we're off the record. In this court, to be successful on probation, you need to stay in contact with probation. If there's an issue with probation, let the court know. And we will take up those matters.
Definitely, Your Honor.
All right. Thank you.
Thank you.
Hello. How are you doing today?
I'm doing good. Thank you.
How's treatment coming along for you?
Treatment? It's been a journey, but I've been working with it. It's been kind of hard. As you know, I had a slip up there, and but I've been doing my recovery every day, and it's one of those things I've never experienced this before. I did have a drinking habit when I was younger, and it just increased during my divorce. I went through a foreclosure. I had some things going on in my life, but that's not an excuse.
All right, everyone, please whisper.
But it's something that I've been it's been difficult, but it's definitely been a learning process.
Okay. So what tools did you learn to make sure you maintain your sobriety?
Well, for one, I'm understanding that my emotions aren't, it's not worth getting in trouble for. I've learned how to relax and calm down. I have 5 children. So, they test you, I have a 20-year-old and 18-year-old. Those are the two that really test me. But at the same time, they're growing up. So it's something that I've been able to process. And I did go to rehab for a little bit. And during rehab, we had process groups, and I was able to release a lot of things that happened. My ex-wife was murdered, and that was tough. It's something that we had to experience as a family. So I gotta say, even though I didn't like getting arrested, it's definitely been something that I needed. And never thought I would say that, but yeah.
And if you're drug tested today?
I mean, I'd be fine. I get drug tested every week.
Yeah, I read the report
Oh,
that since you've been getting drug tested every week, your tests have been better, coming out negative, which is a good thing.
Thank you.
Okay. All right. And I saw where Child Protective Services, I assume, got involved because of this. What's happening with that?
Oh, actually, it was a really positive experience, believe it or not. The lady was super sweet. She came by, she spoke to my mom, she spoke to my children, she spoke to me, she spoke to the person that I work with. And I have to say, it was a relief because she was a really nice lady. And she never contacted me after that. So I'm really not sure what happened with that. But I know that it was a good thing. She asked me if I needed anything to give her a call, and which I appreciate. And any other resource that I could use, it helps.
Okay. All right. So you understand that you have children who are depending on you.
Yes, ma'am.
Your mom depending on you.
Yes.
The family unit is depending on you. And sometimes when you do drugs, that could be the last time that you do drugs, and you don't want anybody having to identify you, because if something were to happen to you, that's going to be more drama and trauma to your children.
Yes.
Okay. So what did you learn from parenting classes?
Parenting classes were good. I've taken parenting classes in the past, and I have to say it's a good refresher. I have to say I'm, it doesn't come with a pamphlet being a parent, but I feel like I'm not sure right now. You caught me off to some time. I apologize.
No
I wish I
problem.
would have had a better answer. a little
No,
more witty.
people always wonder why, when people come here for a criminal charge,
Yes.
that I always want to know about your life. Do you have children in the house, and why I'm always giving parenting classes? Because people think, oh, that has nothing to do with anything. But it has a lot to do with a lot of things,
Yes.
because sometimes when people have a drug issue, part of the triggers are children, and how am I supposed to handle this? And boundaries are being tested.
Exactly.
Okay. All right. So I'm going to terminate. Here's the thing. Do not, I repeat, if you're going out to celebrate because your probation has been terminated, that celebration should be, I don't know, maybe the Cheesecake Factory with their 90 or 100-page menu.
His case is set to terminate on the 10th, so we would remain until the 10th of this month. Is that okay?
All right, if you,
I mean, I waited this long.
all right, so it's the 10th. But you can still go to Cheesecake Factory. They have a great Caesar salad. Caesar salad is all about the dressing.
It is.
Yeah, but you can go there and celebrate with your children, or some other place. They have a new place here called Bojangles or something.
Chicken tenders supposed to be really good.
I haven't tried it.
My friend is the owner.
Oh.
Nice.
All right. So, in my understanding, their prices are great. So look at us. We got an insight to Bojangles.
I know.
Maybe they have some delivery. I don't know. All right, so what's going to end up happening if there are no issues with you, then your probation is going to terminate on the 10th.
Okay,
And the last time I checked the calendar, today is the 8th.
yes.
So 2 days and you will be done. Well, I hope you've learned a lot from probation, and I hope
I did.
I won't see you here again unless you just come in to drop in to say hi.
Well, that's, the parking's kind of expensive.
All right.
Thank you
Yes.
very much, Your Honor.
Your Honor,
welcome.
I just want to confirm, the termination, did you want that satisfactory or unsatisfactory?
Well, we can do terminate satisfactory.
Thank you, Judge.
Thank you.
All right, you're welcome. And does he need to report any more this month?
So-
We'll talk. I'll
Okay.
look at the calendar.
All right, thank you. Have a
Thank you
great
very
rest
much
of your
for
day.
time. I appreciate it.
All right, let's wrap this up. Because what we just watched was a perfect example of how two people can enter court with totally different mindsets and get totally different outcomes. In the first case, Leila McFarland was already on deferred adjudication for assaulting a peace officer, and when she violated the residential program condition, especially with behavior that Judge Boyd clearly viewed as serious, she lost the privilege of probation. The court granted the motion, adjudicated guilt, and sentenced her to 3 years in prison, plus the long-term consequences of a felony conviction and restrictions that come with it. The judge's final message was blunt but fair. Mental illness is real, but it can't be used as a shield for cruelty and disrespect. In the second portion, we saw Christopher Trinidad facing a deadly serious charge, aggravated assault with a deadly weapon, yet still receiving deferred adjudication with strict conditions. Fines, community service, BIPP courses, parenting classes, employment proof, no contact orders, and weapon restrictions due to an affirmative family violence finding. That was Judge Boyd giving a chance with guardrails. And now I want to hear from you. Who do you think handled their court moment worse, Leila or Christopher? And do you think Judge Boyd was too strict or exactly right?